There was a recent decision of the full bench of the Commission, which went all the way to the actual federal court, which dismissed the appeal, in which penalty rates on a Sunday in the Restaurant Industry Award were reduced by 25% for certain classes of employees. Now you'll all be thinking, well, that's a very minor thing. But in terms of what's going to happen in the next 12 to 24 months of industrial relations, I don't think it's a minor thing at all. The Modern Awards, which commenced in 2010, are going to be subject to a 4-year review process during the course of 2014 and 2015. There was a 2-year review process, which was much less significant than the process we're about to go through, and the change that's happened to the Restaurant Industry Award was part of that 2-year review process. And there were to be no changes unless there were cogent reasons for the change. So what happened was a whole lot of the Restaurant and Catering Industry Association and a number of restaurants brought a huge application to the Fair Work Commission at first instance in relation to changes to penalty rates and other factors in the Restaurant Industry Award, which was unsuccessful at first instance, and it included all sorts of things, including virtual abolition of penalty rates, so it was always going to be unsuccessful. But sensibly, there was an appeal in relation to a couple of key issues, and one of the issues was the differentiation between Saturday rates and Sunday rates. And the points that were made in the case, and it's a large case, and there was a huge volume of evidence, were that there is no longer the need for such a distinction between Sunday rates and Saturday rates, and it was time for them to be brought closer together. And in effect, and eventually they were successful in having the Sunday penalty rate for certain classes of employees under the Restaurant Industry Award reduced by 25%. The union, the relevant union, the United Voice, immediately rushed up to the federal court to challenge this because it's a quite significant thing. I mean, penalty rates are something that the union movement valued very highly and something that makes flexibility in business relatively difficult. One of the really interesting aspects, which I'll go on to talk about as to why it has implications for everyone outside, potential implications for everyone outside the restaurant industry, is the evidence that was brought before the Commission and the evidence that the Commission gave value to. There were all sorts of reports, including no doubt highly expensive reports from PwC, etc., regarding elasticity of labour and the impact of a reduction in rates allegedly on employment in the sector, which were completely disregarded by the Commission. They said they weren't interested in that at all. What they were interested in, and what ultimately was probably the most significant factor in leading to a decision to reduce these rates and allow more flexibility for cafes and restaurants to open on a Sunday, was the evidence of the actual business owners. Evidence statements that were largely unchallenged of the business owners in relation to what they would do if they could open on a Sunday, because many of them just simply couldn't open on a Sunday because of the prohibition of the penalty rates. It wasn't evidence that was just made up, and it was certainly dismissed with some people who might have statements that were put forward in surveys, again, that were done by PwC, which were unchallenged material where people were making all sorts of assertions about things were dismissed. But proper evidence that was put forward about the difficulties, both in compliance terms as well as in flexibility terms from the business owners, was given an enormous amount of weight and was one of the determinative factors in a decision which, as I say, the unions are very upset about, but signals some degree of movement in relation to penalty rates potentially for the future. The implications for the restaurants and cafes are, at this stage, are relatively straightforward in the sense that the vast majority of employees in that industry are paid award rates. There's not many enterprise agreements. They are paid the minimum that they're required to be paid under the Modern Award, and it simply meant a reduction in the costs of opening a restaurant or a cafe. Well, I think it was about 18% or something. in terms of staffing costs on a Sunday, and the implications are immediately that those organisations may be able to be open. There was a lot of talk about the implications on the employees. That wasn't ignored by the full bench at all. And one of the reasons that they narrowed the type of employees to lower level employees that this reduction was affected was the evidence that most of the employees who were in that part of the sector were in fact students, or perhaps people with family responsibilities who wanted to work Saturday and Sunday, so that they, at time that they could work because they had other commitments. So it wasn't ignored, but ultimately the evidence of the restaurant and cafe owners, which was tested and accepted in relation to the capacity to actually open on a Sunday, which is what the consumers want and what the staff want, was what contributed to the decision. So, the question is, what are the implications more broadly? And as I mentioned before, we're about to embark, or it's partly already embarked, on a process of review of all the modern awards. Some industry groups made submission to the Fair Work Commission that penalty rates should be considered a common matter that should be looked at in all of the awards, and that was rejected by the Commission. However, they have indicated that it could be relevant to a number of the what we call the Group 4 awards, which includes the Restaurants Award, the Retail Award, a number of the awards that are particularly affected by the issue of penalty rates and run industries that are 7-day a week. So the award modernisation process, as well as grouping some of the awards and having fewer awards, is going to look at issues such as compliance costs, penalty rates, practical factors that employers are having difficulty with in relation to the modern awards. They're not necessarily going to agree with everything that employers say, but I think it's very important that employers and small businesses are aware that the Commission is genuinely interested in individual experiences. You don't necessarily have to, you don't need to have a lawyer or anything. It's something you just would independently do to give an experience in relation to, this is what is happening in my business, these are the difficulties that I'm facing. If you go too hard, as if you just want to remove employees' entitlements, obviously they're not going to pay attention to you. But if you have a sensible approach indicating, well, these are some of the technical compliance difficulties which we are facing because of these modern awards, all the evidence is, from what I have seen, that you will be listened to. For example, a submission has been made in relation to the award modernisation process by one of the leading payroll companies about the fact that the way the car allowance kilometres is in all the modern awards is incredibly difficult from a compliance basis for payroll, both in-house and external, to implement. This is the sort of thing that genuinely the Fair Work Commission is interested in hearing. It's not, no one's attempting to rip off employees, they're just attempting to make things a little bit simpler. So what I would say in relation to, the reason I raise this penalty rates and what's going to happen in the next 12 months is what I would say to anyone who's involved in industrial relations or running a small business is, have a think about any issue that you're finding really, really difficult in relation to your modern awards. And if it's not about just trying to, just not about just trying to rip employees off, but it's about something that is difficult, that could be overcome in a sensible way, it is worth thinking about making a submission yourself. Not through the lawyer, not incurring any costs, but just a sensible submission.